Once employed, which agreement will be followed, the offer letter or the labor contract? They both can be followed. It depends on sort of, I guess, which provision may be in dispute. But the offer letter and the labor contract, they're just pieces to the puzzle, if you will. So an employment relationship is governed by a number of undertakings. There's an employment contract, there's an offer letter, there's any other amendments to the employment contract, there's bonuses, there's commissions, there's other undertakings that could have happened between the company and the employee. So all of these documents comprise their employment relationship. And so it's just a matter of how you prove what the employment relationship was and the terms and conditions of employment. And so each one of these documents can be relevant and will be reviewed by courts. But generally speaking, so if there's a discrepancy between the offer letter and the labor contract, anything that's more favorable to the employee will be upheld. And it's not just necessarily the document itself, it could be specific provisions. So for example, if the offer letter, the notice period in the offer letter is more generous than the labor contract, you could argue, the employer could argue that you should be bound, or the company should be bound to a longer notice period because that's more beneficial to the employee. The general principle is that whenever there is a discrepancy in agreements, the discrepancy is interpreted in favor of the weaker party, and the weaker party in this case is the employee.